Dear friends, welcome to EPG Pathshala. Myself, Dr. Anish V. Pillai, Assistant Professor, School of Legal Studies, Cochin University of Science and Technology, Kerala. Today, I will be discussing about the module of force, criminal force and assault. The learning objectives of this particular module is that to make the learners understand about the concept of force, criminal force and assault. Secondly, to give an idea about the constituent elements of offense of use of criminal force and assault. Thirdly, to give a brief idea about various aggravated forms of assault or criminal force provided under Indian Penal Code. Now, every individual has a right to live in this society without any unreasonable interference by others. However, sometimes people may interfere with the body of others by threat or force. Any such interference using threat or force is considered as a criminal act, as it affects the mental and bodily well-being of the person to whom the said act is committed. Hence, the Indian Penal Code 1860 declares such unreasonable interference as an offence of use of criminal force and assault. Sections 349 to 358 of the Indian Penal Code provides details about various aspects of these offences. Starting with the concept of force, Section 349 of the Indian Penal Code defines what do you mean by force for the purpose of this particular code. The term force means the exercise of one's energy upon another human being. It may be exercised directly or indirectly. In order to constitute force, there must be at least the causing of motion, change of motion or cessation of motion in another. It was explained in the case of Jairam versus Emperor, the accused raises his stick to strike the victim. The victim, seeing the accused raising the stick, moves away. Accused is said to use force within the meaning of this section. The force contemplated in this section is force against a human being and not against an inanimate object. Hence, any application of force to a particular object which is not a human being or an animal cannot be considered as a force for the purpose of this particular section. In the case of Meiko versus the state, it was held that if any motion, change of motion or cessation of motion is caused to any property without affecting a human being, there is no use of force within the meaning of section 349. So, it must be remembered that this particular section is applicable only if it is applied against a human being. Likewise, force does not imply a causing or cessation of motion by personal contacts. However, the presence of the parties are essential under this section. It was explained in the case Biharilal that the section contemplates the presence of the person to whom it is used, that is to say, it contemplates the presence of the person using the force and of the person to whom the force is used. Hence, in order to attract section 349, it is necessary the presence of both the persons against whom the force is applied and the person who exercises such force. Inducing an animal to move may even amount to using force. Likewise, inducing an animal to attack a human being also amounts to use of force. It was so held in the case Indri Kanna Kondaya case in 1923. In the case of Shio Pratap Singh versus Emperor, it was held that driving cattle by shouts and cries does not amount to use of force under this section. Now we can discuss about various offences based on criminal force. First of all, the use of criminal force. This offence is discussed under section 350 of the Indian Penal Code. As per section 350 of the Indian Penal Code, the following are the essential ingredient to constitute the offence. There must be an intentional use of force. That is the first ingredient. The second ingredient is such force must have been used without the person's consent to whom the force is applied, and such application of force is with an intention to cause or knowing it to be likely that by the use of such force he will cause injury, fear or annoyance on the person to whom such force is used. So these are the essential ingredients to constitute the offence of criminal force. The nature of this offence is that it is a non-cognizable offence and it is bailable as well as it is compoundable by the parties with the consent of the court, and it can be tried by any magistrate. The punishment for this particular offence is imprisonment, which may extend up to 3 months, or with a fine which may extend to 500 rupees, or with both. Now coming to the next offence, that is assault, which is discussed under 351 of the Indian Penal Code. Assault means putting someone in fear of immediate unlawful personal violence. It is an unlawful attempt to do a bodily hurt to another coupled with the present ability and intention to do the act. As per section 351, the following are the ingredients to constitute the offence of assault. That is, there must be a gesture or preparation. Such gesture or preparation must be with an intention or knowledge to cause an apprehension to use criminal force. It should be remembered that the apprehension of the use of criminal force must be from the person making the gesture or preparation, and if that apprehension arises not from that person but from somebody else, it does not amount to assault on the part of that person. While determining the apprehension for the purpose of this offence, the ability of the alleged accused is an important factor. So it should be noted that the ability of the offender to cause a particular act is an important factor while determining the apprehension under section 351. Then the apprehension required for constituting the offence of assault must be about an imminent one. It should not be something which is, for example, I will kill you after 10 days. That cannot be considered as an apprehension which is in near future, and it is something which is not imminent one. So such type of apprehension cannot be considered as for the purpose of section 351. The nature of this offence is it is not cognizable and bailable as well as compoundable. It can be tried by any magistrate. The punishment prescribed for this particular offence is imprisonment up to 3 months or with a fine which may extend to 500 rupees or with both. Now we will discuss about various aggravated forms of the offence of criminal force and assault. Starting from the first offence, that is the offence of deterring public servant from discharging his duty. This offence is discussed under section 353 of the Indian Penal Code. As per section 353 of the Indian Penal Code, the following are the important essential ingredients. First of all, there must be an assault or use of criminal force. Such assault or use of criminal force must have been made on a public servant. It must have been on a public servant while he was acting in the execution of his duty, or with intent to prevent or deter him from discharging his duty, or in consequence of anything done or attempted to be done by him in the discharge of duty. So these are the essential ingredients to constitute this particular offence. Now the nature of this offence is cognizable, bailable and non-compoundable. Remember, this offence is non-compoundable offence. That means the parties cannot compound or compromise this particular offence, and this offence can be tried by any magistrate. The punishment for this offence is an imprisonment up to 2 years and fine or both. Now coming to the next aggravated form of assault or use of criminal force is outraging the modesty of woman. This offence is discussed under section 354 of the Indian Penal Code. As per section 354 of the Indian Penal Code, the following are the essential ingredient of this offence: that there must be an assault on a woman, that the accused must have used criminal force on her, that the criminal force must have been used on the woman intending thereby to outrage her modesty. Here you have to remember the concept of outrage modesty. That is very important thing while discussing this particular offence. In the case of Ramkrumal, son of Shamlal Charmarkar versus State of Madhya Pradesh, it was held that modesty in section 354 is an attribute associated with female human being as a class. It is a virtue which attaches to a female owing to her sex. Further, in the case of Keshav Pradhan versus State of Orissa, the Honorable Supreme Court observed the test of outrage of modesty is whether a reasonable man will think that the act of the offender was intended to or was known to be likely to outrage the modesty of the woman. Hence, the concept of outrage the modesty of woman is very important while discussing this particular section. Another question arises in this regard is from what age a woman has modesty. It was discussed in various cases, and in cases where the court said that even a girl of 6 months old can have also the modesty. Now, the nature of this offence is cognizable. Remember, unlike other offences, it is a cognizable offence, and it is bailable and it is non-compoundable. It is triable by any magistrate. The punishment for this particular offence is imprisonment for a period minimum 1 year and maximum up to 5 years and a fine. Now coming to the next aggravated form of assault or use of criminal force is the offence of to disrobe woman. This offence is discussed under section 354B of the Indian Penal Code. This offence was introduced by Criminal Law Amendment Act. The next important aggravated form of offence is that the offence of to disrobe woman. This offence is discussed under section 354B of the Indian Penal Code. It is a new provision inserted by the Criminal Law Amendment Act 2013 on the basis of Justice Verma Commission. This Justice Verma Commission was appointed as a result of the mass protest on the basis of Delhi gang rape case. As per section 354B, the ingredients to constitute this particular offence of to disrobe woman are: there must be an assault or use of criminal force or an abatement. Secondly, it must be against a woman, that too with the intention of disrobing or compelling her to be naked. So this is a new provision which is intended specifically to prevent the recent trends, recent crimes against women. The nature of this offence is that it is a cognizable offence, and most importantly, this offence is non-bailable as well as non-compoundable, and it can be tried by any magistrate. The punishment for this particular offence is an imprisonment not less than 3 years, but it may extend up to 7 years and also fine. The next important aggravated form of this offence of use of criminal force and assault is assault or use of criminal force to dishonor another person. This offence is discussed under section 355 of the Indian Penal Code. As per section 355 of Indian Penal Code, the following are the essential ingredients to constitute this offence. First of all, there must be an assault or use of criminal force. Such assault or use of criminal force must be with an intention to dishonor that person otherwise than on grave and sudden provocation. So it should be remembered that this offence is applicable only if there is no sudden and grave provocation on the part of the person where there is a dishonor was happened. The nature of this offence is it is a non-cognizable offence, it is bailable and compoundable. This offence can be tried by any magistrate. The punishment for this offence is an imprisonment up to 2 years and also fine. The next important aggravated form of use of force, use of criminal force and assault is the offence of assault or criminal force in attempt to commit theft of property carried by a person. This offence is discussed under section 356 of the Indian Penal Code. As per section 356 of the Indian Penal Code, the following are the essential ingredients to constitute this offence. First of all, there must be an assault or use of criminal force to another person. Secondly, the other person must wear or carry the property. Thirdly, the accused must attempt to steal such property. Hence, if these 3 ingredients are satisfied, this particular offence will comes into picture. The nature of this offence is it is a cognizable offence and it is bailable as well as it is non-compoundable. This offence can be tried by any magistrate. The punishment for this particular offence is an imprisonment up to 2 years and a fine. The next aggravated form of offence is that the offence of assault or criminal force in attempting wrongfully to confine a person. Section 357 of the Indian Penal Code provides the details about this particular offence. As per Section 357, the essential ingredients to constitute this offence is that there must be an assault or use of criminal force to another person. The said assault or criminal force was did so in attempting to wrongfully confine the person who is assaulted or against whom the criminal force is used. The nature of this offence is it is a cognizable offence and bailable offence. It is compoundable and triable by any magistrate. The punishment includes imprisonment up to 1 year or a fine of rupees 1,000 or both. Now coming to the last aggravated form of this offence is that the offence of assault or criminal force on grave and sudden provocation. The various details of this offence is mentioned under section 358 of Indian Penal Code. As per section 358 of the Indian Penal Code, the following are the essential ingredient. That is, there must be an assault or use of criminal force to another person. Such use must be on grave and sudden provocation given by that person. Now here the question is, what should be the test can be used to determine grave and sudden provocation? In various cases, the court has discussed in detail this question, and the court has concluded by saying that the test of grave and sudden provocation is whether a reasonable man belonging to the same class of society as the accused placed in the situation in which the accused was placed would be so provoked as to lose his self-control. Sometimes the words and gestures may also cause grave and sudden provocation to an accused. It was so held in the case of Venkatesan versus State of Tamil Nadu in the year 1997. The nature of this offence is non-cognizable and it is a bailable offence as well as it is compoundable and it can be tried by any magistrate. The punishment for this offence is imprisonment up to 1 month and a fine up to 200 rupees. Now, after discussing all these things, we can come to the conclusion. I will quickly tell you the important points which we have discussed. That is, the law relating to force, use of force and assault are explained under sections 349 to 358 of Indian Penal Code. The Indian Penal Code first defines the concept of force under section 349. Subsequently, the code explains about the offence of use of force and assault under sections 350 and 351. Further, Indian Penal Code categorizes the offence of use of criminal force and assault into different aggravated forms on the basis of involvement of certain special circumstances. Section 349 says that a person is said to use force to another if he causes motion, change of motion or cessation of motion to that other, or if he causes any substance, such motion or change of motion or cessation of motion as brings that substance into contact with any part of that other's body or with anything which that other is wearing or carrying or with anything so situated, such conduct a person is said to use force to another if he causes motion, change of motion or cessation of motion to that other, or if he causes to any substance such motion or change of motion or cessation of motion as brings that substance into contact with any part of that other's body or with anything which that other is wearing or carrying, or with anything so situated that such contact affects that other's sense of feeling, provided that the person causing the motion or change of motion or cessation of motion or causes that motion, change of motion or cessation of motion in one of the three ways hereinafter described. Firstly, by his own bodily power. Secondly, by disposing any substance in such a manner that the motion or change of motion or cessation of motion takes place without any further act on his part or on the part of any other person. And thirdly, by inducing any animal to move, to change its motion. Sir James Stephen said, "It is the most singular definition in the whole code. The object of this section is to provide a clear understanding about the concept of force for the purpose of other subsequent sections, such as sections 350 to 358. Under the terms of these sections, to cause motion, change of motion, or cessation of motion by one other of the three means mentioned to another person, either directly or indirectly bringing some substance into contact with his body or with something that he is wearing or carrying, or with something that thereby affects his sense of feeling, is to use force." The various terminologies used in this section for defining force are exemplified by illustrations given under section 350. Illustration A exemplifies the word motion. It states that Z is sitting in a moored boat on a river. A unfastens the moorings and thus intentionally causes the boat to drift down the stream. Here, A intentionally causes motion to Z, and he does this by disposing substances in such a manner that the motion is produced without any other action on any person's part. Illustration B exemplifies the word change of motion. It provides that Z is riding in a chariot. A lashes Z's horse and thereby causes them to quicken their pace. Here, A has caused change of motion to Z by inducing the animals to change their motion. A has therefore used force to Z. Illustration C exemplifies the word cessation of motion. It provides that Z is riding in a planking. A intending to rob Z seizes the pole and stops the planking. Here, A has caused cessation of motion to Z, and he has done this by his own bodily power. A has therefore used to force to Z. Illustration D provides an example for the idea: bring that substance into contact with any part of that body. It provides that A intentionally pushes against Z in the street. Here, A has by his own bodily power moved his own person so as to bring it into contact with Z. He has therefore used force to Z. Illustration G exemplifies the idea of others' sense of feeling. It provides that Z is bathing. A pours into the bath water which he knows to be boiling. Here, A intentionally by his own bodily power causes such motion in the boiling water as brings that water into contact with Z or with other water so situated that such contact must affect Z's sense of feeling. A has therefore used force to Z. In order to constitute force, there must be at least the causing of motion, change of motion, or cessation of motion in another. This conclusion is for the module Classification of Criminal Law. Thank you for watching this video. I hope you have understood the basic concepts regarding the classification of criminal law. Thank you.